Hello, this is for Chapter 5, Security and Privacy of Information Belonging to Children and in Educational Records in the textbook Legal Issues in Information Security. This is for the course ISOL 633 for the University of the Cumberlands. Several laws are in place in the United States to protect children when they are online. The Children's Online Privacy Protection Act, or COPPA, C-O-P-P-A, governs how information from children is to be collected and used. If you host a website that collects information from children, COPPA applies to you. The Children's Internet Protection Act, or CIPA, CIPA, protects minors from obscene or objectionable material on school or library computers. These computers must implement technology to filter objectionable content. The Family Education Rights and Privacy Act, or FERPA, F-E-R-P-A, protects the privacy rights of students and their educational records. Students and parents have the right to review these records. Additionally, schools cannot release records without the written consent of a student or parent. This chapter begins with a discussion of children and the internet and the unique challenges website operators face in protecting children. The chapter then provides details about COPPA, CIPA, and FERPA. So the learning objective for this chapter: describe laws that protect children on the internet and laws that protect information of children in educational settings. So the chapter will cover what challenges exist in protecting children on the internet, what the Children's Online Privacy Protection Act, or COPPA, is, what the Children's Internet Protection Act, or CIPA, is, and what the Family Education Rights and Privacy Act, or FERPA, is. So key concepts we will look at include protecting children on the internet. Again, we'll take a look at FERPA, at Family Education Rights and Privacy Act, and COPPA, the Children's Online Privacy Protection Act, CIPA, the Children's Internet Protection Act, and understand the differences between purpose and scope of FERPA, COPPA, and CIPA. So challenges in protecting children on the internet. U.S. children ages 8 to 18 spend over 7 hours a day using electronic media. This includes television, music, computer use, and video game use. Parents, schools, and website providers all have different roles to play in protecting children when they are online. Although most people agree that children should be protected when they are online, they don't always agree on how that should be accomplished. For example, some people suggest that parents should monitor a child's internet access and decide if the child's internet activities are acceptable. Others suggest that laws should be in place to protect the child even if a parent is not monitoring the child's internet use. As you will see in this chapter, several laws have been enacted to protect children. Most of these laws are directed at the website operators who provide online content to children. However, even when enacting laws, challenges still exist. They include identification of children. How can website operators distinguish between adults and children online? First Amendment and censorship. When does censoring certain types of content violate the First Amendment? And defining objectionable content. Where is the dividing line between material that is merely inappropriate for children and that which is truly objectionable? It is hard to separate children from adults on the internet. To protect children, you must be able to identify them. Although it can require identification from restaurant customers to ensure they're old enough to purchase alcohol, it isn't easy to acquire identification when users access a website. Most users can easily maintain an anonymous when they're online. This creates a problem for website operators. Most of the laws that aim to protect children while they're online require website operators to be able to protect children, to be able to distinguish children from adults. So the First Amendment and censorship. The First Amendment is a part of the Bill of Rights. The First Amendment grants certain rights related to freedom of speech. It also protects freedom of the press and free exercise of religion. First Amendment issues come into play on the internet in many different ways. Individuals online have a First Amendment right to view lawful content, including content that others might find troubling. Website operators and other content creators have a First Amendment right to post lawful content, including content that others might find troubling. The U.S. Supreme Court has said that the right to freedom of speech applies to the internet. This means that the government can't restrict an adult's access to content on the internet. However, the government can restrict a child's access to harmful online material if the government has a compelling reason to do so. Defining obscenity. Laws discussed in the chapter protect the privacy of children. They protect children from harmful content. For the most part, this harmful content is content that would be considered obscene. Most people agree that children should not see obscene material. However, it's difficult to legally define what obscene material is. The U.S. Supreme Court addressed this in 1973. In Miller versus California, the court said that for material to be identified as obscene, it must meet three conditions. The conditions are based on the average person applying contemporary community standards to a review of the material. These three conditions are that the material applies predominantly to prurient interest. Prurient includes a morbid, degrading, and unhealthy interest in sex. Depicts or describes sexual conduct in a patently offensive way, and lacks serious literary, artistic, political, or scientific value. Children's Online Privacy Protection Act, or COPA. Children's Online Privacy Protection Act passed in November 1998. It first went into effect in April 2000. COPA governs how websites collect information from children under the age of 13. The Federal Trade Commission, or FTC, oversees COPA compliance. It has the power to make rules for COPA compliance. The FTC rule governing COPA is called the COPA Rule. This rule was first drafted in 1999. In 2012, the FTC revised the rule to respond to changes in technology. New rule gives parents more control of how their children's information is used. The revised rule went into effect in July of 2013. Websites must follow specific rules under COPA to collect and use information from children. There are several important definitions in the COPA rule. A child is any person under the age of 13. A parent is the legal guardian of a child, and an operator, a website operator or operator of an online service who collects or maintains personal information from users. COPA has two main rules that websites must follow in order to comply with the rule. Operators must, number one, post a privacy policy, and number two, give verifiable parental consent before collecting information from children. Under COPA, websites must post a privacy policy. The privacy policy states the kind of information the site collects from children. Also states how the site will use the information. The COPA rule tells operators the terms they must be included in the privacy policy. COPA has specific rules about getting parental consent. This consent is required if a website wants to use and collect data from a child. Website operators must take reasonable steps to make sure that a parent receives direct notice of an operator's data collection practices. Under COPA, parental consent must be verifiable. Only a parent can give consent. The website operator must verify the identity of the parents that it contacts. This becomes especially important if the parent requests to see the information held about his or her child. Website operators must have measures in place to prevent the information from being released to the wrong party. The Children's Internet Protection Act, or CIPA, was passed in 2000. It requires schools and libraries that receive funding from the U.S. government for Internet access to filter offensive and sexually explicit online content. These schools and libraries had until July 1, 2004 to comply with CIPA. The goal of CIPA is to limit children's access to offensive content on the Internet. Under the Children's Internet Protection Act, a minor is anyone under the age of 17. The primary purpose of CIPA is to protect minors from accessing offensive content on the Internet. Offensive content includes any visual depictions that are any of the following: obscene, child pornography, or harmful to minors. So the scope of the regulation is any school or library that receives federal funding from an E-rate program must comply with CIPA. The E-rate program provides discounts to most schools and libraries for Internet access. Schools and libraries don't have to accept these funds. They can either pay for the Internet access with other funds or choose not to use the Internet. CIPA has two main requirements. First is that schools and libraries that accept E-rate funds must implement technologies that filter offensive visual content so that minors don't access it. The second requirement is that schools implement an Internet safety policy. According to CIPA, a school or library must be able to disable their PTM for any adult who has made or to review content for search or other lawful content. An adult is anyone over the age of 17. If a school or library refuses to disable the Technology Protection Measure, or TPM, for an adult that requests it, the school or library is potentially infringing on the First Amendment right of that adult. This is because they are censoring adult access to protected content. Under CIPA, an adult doesn't have to state why he or she wants the technology protection measure disabled. So proxy server used for content filtering. The primary requirements of CIPA mandate the filtering of content. Offensive content must be filtered so that minors can't see it. Although this may seem difficult, there are tools to make the job easier. CIPA's terms for such a tool is Technology Protection Measure, or the TPM. The TPM is any technology that can block or filter the objectionable content. Remember that under CIPA, PTM must filter visual content. If you look at the figure on your screen, this figure shows a proxy server used to filter content. The proxy server accepts internet requests from clients, retrieves the pages, and serves them to the client. The content filters filter out objectionable content. As shown, you'd configure the internet clients to access the internet through a proxy server. The proxy server has a content filter. This content filter blocks all content marked as unacceptable. Some filters can also block content to email and instant messaging programs. Similarly, filters allow all content marked as acceptable. The proxy server identifies what's acceptable based on filter lists. Third-party companies sell subscription to filter lists. The companies constantly search the internet. They identify the restricted materials and add it to the filter lists. When the network administrator adds the filter to the organization's proxy server, the server blocks the prohibited material. So where do COPPA and SIPA apply? They apply to commercial websites. They apply to online services. They apply to educational institutions like schools. They also apply to libraries. So COPPA and SIPA, the U.S. Congress Protection Acts, the Children's Online Privacy Protection Act, or COPPA, was enacted in 1998, and SIPA, the Children's Internet Protection Act, was enacted in 2000. The reason for that is that children are becoming or have become internet ready and receptive. The children still lack the judgment and knowledge of dangers, and they also still lack the knowledge to evaluate the merits of information. The Family Education Rights and Privacy Act, or FERPA, was passed in 1974. The primary goal of FERPA is to protect the privacy of student educational records. An educational record includes any personal and education data on a student maintained by an educational agency or institution. Under FERPA, parents have the right to inspect and review a student's educational records. These rights do not belong to a parent forever. When a student reaches age 18, these rights pass to the student. So FERPA applies to any educational agencies or institutions that receive funding from the U.S. Department of Education. Educational agencies or institutions include primary and secondary schools, vocational colleges, colleges and universities, community colleges, state and local educational agencies, schools or agencies offering preschool programs. And the phrase educational agency or institution will often be shortened to school. So FERPA has four main requirements: annual notification, access to educational records, addendum of educational records, and disclosure of education records. To carry out these requirements, FERPA has several important definitions. They include a student, as any individual who has ever been in attendance of an educational institution and for whom the institution maintains educational records. Attendance, a student's physical attendance at an educational institution. It includes any virtual attendance, such as a video conference or correspondence courses. Attendance via the internet, by satellite, or through other methods used by the school are also included. Education records, any records related to a student maintained by an educational agency or institution. These include written documents, computer media, video, film, or photographs. Records maintained by any outside party acting for the agency or institution are also included. FERPA also defines personal identifiable information, or PII, and places limits on how this data can be used and disclosed. Under FERPA, the personally identifiable information includes a student's name, name of the student's parents or family members, address of the student or the family, personal identifiers such as a social security number, student number, other identifiers such as the student's date of birth, place of birth, mother's maiden name, other information that's connected to a specific student that would allow a reasonable person in the school community to identify the student, and information requested by a person who the school reasonably believes knows the identity of the student to whom the education record relates. So, school disclosure exceptions. The school can release student records without prior consent in some cases. As mentioned earlier, school officials such as principals or teachers can view student educational records. These officials must have a legitimate educational interest to view the record. School officials can't view a student record merely if they are curious about a student's performance. FERPA allows a school to disclose student information in a number of other ways that don't require prior written consent. Schools can transfer a student's educational record to a new school if the student is moving from one school to another. Schools can provide student information to an accrediting organization to prove that the school is performing to specific standards. Schools can provide student information in some financial aid situations. Schools can disclose student education records in response to a court order or a subpoena. School must disclose student information if it will aid personnel in an emergency situation. And post-secondary schools can disclose personal information of a student over age 18 to the student's parents if the student is considered a dependent for the U.S. federal tax purposes. So directory information includes their name, address, phone number, date of birth, place of birth, honors or rewards that they have received, and dates of attendance. So this chapter covers several laws designed to protect rights of children and students. The Children's Online Privacy Protection Act, or COPPA, protects the information of children, prohibits websites from collecting information about children without parents' consent. COPPA defines a child as anyone under the age of 13. The Children's Internet Protection Act, or CIPA, requires schools and libraries to filter website traffic. CIPA ensures that students don't view objectionable material from these publicly funded locations. CIPA defines a child as anyone under the age of 17. Family Education Rights and Privacy Act, or FERPA, requires schools to protect educational records. Schools need written consent prior to releasing educational records. The student or parent has the right to review these records, and FERPA grants these rights to parent until the child reaches the age of 18. At that point, the right passes to the student. Thank you.